Welcome to the August 28 meeting of the Raleigh Historic Development Commission Certificate of Appropriateness Committee. My name is Wes Tripp, and I am chair of the committee. The COA committee is a quasi-judicial body governed by North Carolina general statutes and the city's Unified Development Ordinance. We are authorized to hear requests for certificates of appropriateness. Before we proceed with the cases on today's agenda, we will start with a introduction of the commission. We'll start with Lauren, work our way down. Please introduce yourselves and provide a brief background of your experience.
Sure. I'm Lauren Woodard. I'm an architect here in Raleigh, and I currently live just east of downtown, right off Rock Quarry Boulevard.
My name is Melissa Todd. I'm a licensed architect, and I currently live in a historic overlay district.
And again, my name is Wes Tripp, chair of the committee. I'm an attorney here in Raleigh.
Good evening. I'm Rob Allen. I am an architect in North Carolina and a resident of the Boylan Heights Historic District.
My name is Jordan Ryland. I'm an architect and resident of Raleigh for 15 years.
And staff, please introduce yourselves.
Good evening. I am Erin Morton Pugh. I am a senior preservation planner with the city for 5 years now, and I have a master's in historic preservation.
Hello, everyone. I'm Colette Canane. I'm also a senior preservation planner. I have been with the city of Raleigh for 7 years, and I also have a master's in historic preservation.
And Patrick, our attorney.
I'm Pat Jones. I'm counsel to the committee.
All right. If you've not already done so, please come forward to sign in at the dais. This will help for minutes purposes. First, need to approve the agenda as published. I'll entertain a motion to approve the agenda.
So moved.
Is there a second?
Seconded.
Any discussion or debate? Hearing none, questions, approval of the agenda. All those in favor say aye.
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 Any opposed? Motion carries unanimously. Next, we have approval of the minutes of the July 24, 2025 meeting. Any discussion or debate? Any edits? So I'll entertain a motion to approve the minutes as published.
So moved.
Is there a second?
Seconded.
Any discussion or debate? Hearing none. Question for the committee's approval of the minutes of the July 24, 2025 meeting. All those in favor say aye.
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 Any opposed? Motion carries unanimously. Staff, minor work report.
In the previous month, there were 10 minor works approved, and as a reminder, all of those minor works, including descriptions, application numbers, and addresses, can be viewed on the city's website.
And I'll just add a brief note that we have established quorum here with all 5 regular committee members at the table.
Thank you. All right, before we begin with the agenda, I have a brief introductory comments to make. In hearing cases, the committee conducts a quasi-judicial evidentiary hearing. That means this is like a court hearing. State law sets specific procedures and rules concerning how this committee must make its decisions. These rules are different from some other types of land use decisions like rezoning cases, which are legislative in nature. This committee's decisions are constrained by the standard of review set forth in state law and the UDO and the facts presented at the hearing. The committee hears and considers evidence presented at the hearing and applies the standards set forth in state law and the city's ordinance. The committee must base its decisions upon competent material and substantial evidence presented at the hearing. If you will be speaking as a witness, please focus on the facts and standard, not personal preference or opinion. Participation is limited. This meeting is open to the public. Everyone is welcome to watch. Parties have rights to participate fully. Parties may present evidence, call witnesses, and make legal arguments. Witnesses may testify as to facts to which they are competent to testify, so long as those facts relate to the legal standard. In addition, lay or non-expert witness testimony is limited to facts and not opinions. For certain topics, this committee needs to hear opinion testimony from expert witnesses. These topics include projections about impacts on property values and projections about impacts on traffic safety. We will now conduct the evidentiary hearings on today's agenda. The first item on today's agenda is COA 82-2025. This is 810 through 816 Brooklyn Street. I'll ask the applicant to please come forward, and while they are doing that, I will recognize staff for their presentation.
Could you please swear staff in first?
Oh, thank you for reminding me. Now I will swear the staff in for their presentation of the evidence on today's agenda. Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
I do.
I do.
Thank you.
All right, so as you just mentioned, the first case on the agenda this evening is COA 82, 2025. It is for 4 parcels in Glenwood, Brooklyn, 810, 812, 814, and 816 Brooklyn Street. This application was continued from your July meeting. The nature of the request is to construct 2 primary townhome structures, install a driveway, and install front walks. And you can see the property here on the map. It's at the corner of Brooklyn and Clay. And these photos will be familiar to you. They are unchanged from last month. But this is a view of the current property from the intersection of Brooklyn and Clay, from directly across Brooklyn Street, and at the end of the parcels, and the view from Clay Street. And as a reminder, the structures that are currently on the site were previously approved to be demolished with a 365-day delay. An abbreviated summary of staff concerns, as noted in the staff report, are height, scale, and massing, and material details and specifications that are typically provided as conditions.
All right, thank you. I'll now recognize the applicant for their presentation.
Thank you, Chair Tripp and members of the committee. Molly Stewart, Morningstar Law Group, here on behalf of the applicant, Waypoint. We have with us this evening Andrew Thompson from Waypoint. He was sworn in at the beginning of this hearing last time. I believe he does not need to be sworn in again. Is that correct?
I'll defer to an attorney. Given this is a continuation of the hearing, does he need to be sworn in again?
He does not.
Okay, thank you.
We also have with us this evening David Bryson, our architect on the project, who was not with us last time. So I'd like to bring him up to be sworn in and then to tell us about his qualifications. Thank you.
All right, please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Yeah, so I'm David Bryson. I've been in Raleigh for 40 years. I'm an architect registered in the state of North Carolina and Florida and Tennessee. And I'm here on behalf of the owner, working with him as the architect.
I'd like to tender Mr. Bryson as an expert witness in architecture and design.
Without objection, so moved.
Thank you. Before we get started, I also do have some handouts for tonight. Thank you, Colette. Oh, thank you. That's okay. I'll get these started. Go around and tell them what they're getting. Thank you. Okay, so for the most part, oh, sure. Let me just read off what it is. So what you'll be getting here is some backup to things that you'll hear in the presentation. First, you'll see the staff report for the Certificate of Appropriateness that was granted in 2019 for the 2 duplex units across the street from this site. Also, a map showing calculations of what percentage of the frontage of each parcel is occupied by a building, as well as some changed pages that were reflecting a clarification that was requested with respect to some of the design details related to the picture frame windows, as well as the what previously said picture frame windows and also said vertical siding. Both of those has been determined that those are not applicable, and that has come out. Also, there are new side elevations. Again, a clarification. There was some confusion about the roof material, and that has been updated there to asphalt shingle. And also, just sort of as required, a packet of all of the slides from tonight. Thank you. As I mentioned, none of that is additional information beyond what you'll see in this presentation. So I will go ahead and get started with that. So you see on your screen the purpose and objective of the Streetside Historic Overlay District. This is one of several sort of guiding lights that the project team as a whole has looked to throughout the design process as well as this hearing process. And tonight we do want to hit in particular the topics that you just heard from Colette that were of particular importance in the staff report as well as last time that we were here. And those topics are height. We had a lot of questions about that, so we have brought back more information about the height as well as scale and massing. And then, of course, the style and design features. So those are the three topics that we heard as a continuing concern from last time, so we'll be addressing those this evening. So, and as I mentioned, David Bryson is here in particular to discuss those design details where there are additional questions. So I'll begin by looking in particular at a series of sort of guidelines that we were working in with respect to height in particular. So again, just looking at the street side overlay, which is specifically geared toward conserving character as viewed from the street right-of-way. So that is what is special about the street side historic overlay. And then, of course, you're all familiar with the design guidelines for new construction. This is number 7. In general, number 7 deals with a lot of sort of height, massing, scale, size, those sorts of dimensional factors. And the standard, of course, is that the new buildings should be congruous with. And with respect to height in particular, it gives a little bit more detail, noting that height should generally fall within 10% of well-related nearby buildings. So here in the guidelines, you see sort of a general, that language should generally, so not a bright line rule. And we did look at this last time as well, that a certificate of appropriateness isn't prohibited, where there are some special conditions on the site where compliance would create an unusual and unnecessary hardship. So that's another point that we've brought back some additional information on tonight. So with this, we'll take a little tour around the site. The site is outlined there in yellow. It's a little bit hard to see. Let me draw that. So the site is here. And then starting across the street down to the southwest there, the first thing you see is the surface parking lot. There's a photo there in the top left. That is directly across the street. It is on the same lot as the building shown below it, which is a contributing structure. And you can see from this photo, there have been some modifications to it over the years. There are some differing sources as far as when that happened. Certainly it was after the period of significance and before the historic designation came in. So somewhere in that gap, those changes were made. At the bottom left there, you see the duplex units that were constructed across the street in 2020. So those are non-contributing. Next to those is the 1982 apartment complex also across the street. And then the other big piece to notice here, in addition to these specific sites, is to the north and to the west of the site, we're actually outside of the district. So it's a very diverse area. When you put all that together, the purple here represents the contributing structures that are nearby. And then everything else is either non-contributing or simply not in the district at all, highlighting why this site does face some different challenges from some others that are more nested into the site. So not only are we out here on an island or perhaps a peninsula, depending on how you look at it, there's a great diversity of what's around it. In particular, I want to highlight, not trying to hide the ball, that purple dips down around the surface parking lot. It's on the same parcel as the contributing structure, but given that the focus here is on the view from the street, we took that out as being more reflective of what's there. And what this looks like from the air. So looking toward the west there, you see that 5-story apartment building immediately adjacent, as well as everything to the north there, which is to the right of your screen, that is outside of the district. Just really illustrating those challenges. And here you can see that surface parking lot across the street as well. None of those challenges are bigger than this 5-story apartment building next door, and how to solve that design challenge on this site. So this view is, standing within the district in front of the site. So those two houses that you see there are on the site, but then looking past them, what you see is that 5-story building, very visible from there within the district. And one effect of the proposal being brought to you tonight is to add more height here, to create a transition that actually blocks that view. and actually keeps that out of the visual space of this historic district. Just a quick reminder while we're on height of the wide range of structure heights. So when we see this guideline about staying within the 10% of nearby well-related structures, it's actually not part of the character of the district, and that just showed diversity of heights. These are 3 houses away from each other, immediately next door to each other, so you see great variety, even immediately adjacent. So to get really in the weeds on height, we had some confusion about what the height is last time, and so we have provided new drawings that show this more clearly. And so that roof apex number is at 37 feet 9.5 inches. Just to clear that up, we have our new elevation on this side as well. So as you heard last time, the example structures that were included in our application were not contributing structures within a block and a half. There are taller structures within the district. That certainly is part of the fabric of the neighborhood in general, but it doesn't exist in this tiny area. As you saw, there aren't a lot of contributing structures very close to the site at all. But what we do have is at least a precedent. And so across the street, we have structures that also were not within 10% of the height of nearby contributing structures. These were approved in 2019. The approved height here, 36 feet 4 inches. If we did go 10% up from that, that would put you 2 feet taller than what's being proposed here. So we do have this data, and just as a reminder, what is being proposed, 37 feet 9.5 inches versus this 36 feet 4 inches. So very close as far as overall scale, certainly within the range of differences that you see throughout this neighborhood in general. And just to illustrate that, we have some snips from the Certificate of Appropriateness application highlighting that height. This is all in your handouts. And that that approval that was done in 2019 was for these structures more than 19% taller than the adjacent contributing structures. One other difference with these duplexes across the street is you can actually see in this map, we'll go back to the map, because they share property boundaries with 5 other parcels. You can see it maybe a little bit better here, with 5 other parcels that do have contributing structures on them. That is not true here. The site under consideration tonight does not share any property boundary with any contributing structure. The only sort of adjacent-ish structure would be across Clay Street there to the east. So to move on from the height question, we'll go to massing, and height is obviously a big part of that. And from a street side perspective, what this looks like from the street, you're looking at height and width. And in this case, when you're looking at the rhythm of the buildings on the street, what's really important about that is the percentage of the site frontage that is occupied by a building. And so this map gives those calculations for the surrounding area, and they range. For the contributing structures, you see everything from 63% there on Gaston Street up to 100% for the unit directly across Clay Street from the site, with this site being at 74%, so well within the general range, not making any attempt to change that character. So in summary of the height and the building massing issues, we've discussed today how there isn't a hard and fast rule that requires buildings to be within that 10%. It's a guideline. It is generally, usually that sort of thing. We have also shown that the site is unusual based on its position on this island at the edge of the district. It's surrounded by a very diverse mix of building types and heights, including the recently approved attached dwellings, their attached garages directly across the street. With respect to design, both Andrew and David have worked very hard to ensure that the proposed new homes fit as well as any structure could on a site like this one into its proposed location as well as into the district as a whole. So they've taken into account the form, the design details from styles that are widespread within the district. They've also introduced features to distinguish it from those examples as recommended in the guidelines. Despite being on the edge of the district and facing these challenges of how do you integrate a site that is surrounded by so many different things, the proposed design is deeply reflective of the character of the district and very much in line with recent approvals as well. If there are additional questions on design, I believe there were some uncertainties last time. I would suggest we bring David Bryson up to provide any clarity that's needed on those. With respect to the proposed conditions, we have no objection to those. I think the only piece we would like to add to those conditions is to simply say, that those conditions apply, if applicable, because I understand that they don't all necessarily pertain to an actual proposed part of the design, but in general, we have no objection to those proposed conditions. So with that, we are all available for questions. Thank you.
Thank you, Molly. Are there members of the public who wish to provide comment on the application? All right, please come forward.
What we'll do is we'll, can I click on it and put it on? Okay, yeah, we'll do, it'll kind of work.
Okay.
Sorry about this. We made a modification, it didn't get in on time, so you guys are going to get paper copies, and no, we don't want to do that one.
Okay, you don't want that?
No, I don't want that one,
Okay.
sorry.
No, that's
Well, we'll leave it up there. Go ahead, you can do that one. But we won't put it up first. I'm going to take it off right now. Okay. Thank you.
We'll just pretend that.
Oh, can I make it black this out first?
I don't think that's possible.
I don't want to look at it yet.
Okay. We'll just.
Okay, I'm gonna leave it there. Can you come back up to do it again?
Please state your name.
My name is John Reese, a registered architect in North Carolina.
Before you get going, let me swear you in.
Oh, of course.
You should know, John.
I should know.
Please raise your right hand. You solemnly swear or affirm the testimony you're about to provide is the truth, the whole truth, and nothing but the truth.
I do.
You may proceed.
Thank you. My name is John Reese, a registered architect in North Carolina and a 28-year resident of the Glenwood, Brooklyn neighborhood. I live at 719 Devereaux Street. In 1997, my partner and I purchased and rehabilitated the former Glenwood Grocery, Norden Fresh Mart, now called The Store, as our residence. I've served for a 4-year term as an RHDC commissioner and was a member of this committee from 2020 to 2024. I believe my experience gives my comments both standing and weight. Before Glenwood, Brooklyn became a designated historic district, any request to alter lot lines or setbacks went before the Board of Adjustment. Combined with the special zoning protections our neighborhood fought for, that system safeguarded us from inappropriate development for more than 110 years. Today, those protections rest in this committee's hands, and I fear for our future. I was unable to attend last month's meeting in person, but I watched the live feed. I knew the project would be deferred, but I wanted to hear both the applicant's presentation and this committee's discussion. What I heard and didn't hear was troubling. The staff report omitted any mention of the historic importance of our neighborhood's lot line and setback framework, and no one on the committee asked for that evidence. There was no discussion of lot recombination or the applicant's unusual approach to gain approval. As some of you may recall, my nickname on this committee was the Professor, so in that spirit, let me give you a short history lesson. The Glenwood, Brooklyn neighborhood began in 1905 as Raleigh's first suburban development beyond the 1792 Christmas Plan. Brooklyn Hill, now the district's western gateway, is its oldest section. In 1907, 2 of the 3 houses now slated for demolition were owned and occupied by African Americans. Could they have been remnants from the nearby and long-forgotten Brooklyn Freedmen's Village? I wonder what they would think if they knew their lots would be worth as much as they are, or that they would be the first impression of our neighborhood from St. Mary's Street. The Glenwood Land Company's plat, which still guides our framework today, created modest single-family homes west of Glenwood Avenue with larger homes reserved for Glenwood frontage. Our neighborhood's unique character and scale stem directly from the DNA of that plan. That's why no townhouses exist here until possibly now. Watching last month's meeting, I could not understand why this project was even under serious consideration, so I did my research. The first page you have in front of you is the diagram that the applicant submitted to you to see in the last meeting. It shows lot perimeters, but deliberately omits the historic subdividing lot lines. Interesting. Why? Well, the diagram next, which is, now we can do it. The diagram that you see next is what you need to see. When you overlay the proposed townhouses on the actual historic lots and setbacks, the problem is obvious. 2 townhouses literally straddle existing lot lines. The blue squiggle line that you guys see in the back, it's not on this slide, of the lot, is a stormwater drainage ditch that runs through these 4 properties. Its pervious surface protects not just these properties from flooding, but the rest of their neighbors as well. The applicant proposes to pave over that ditch. They said they're working with the city to resolve the problem. How? Without proper study of stormwater calculations and predictions, no amount of inlets will catch enough of that water to ensure it won't sheet down the hill and then most likely into the backyards of the neighbors along Brooklyn Street on the other side of Clay. We've seen this before. The previous developer bought these same lots. A previous developer bought these same lots. He assumed he could recombine them, and he was swiftly denied by the Board of Adjustment for failing to prove hardship. This applicant is more strategic. Bypass the board, seek RHDC approval first, and use that approval later to justify recombination. In other words, secure a COA that ignores historic lot lines and setbacks. Claim hardship if denied at recombination. Build 6 townhouses instead of 4 houses. Leave with profit while our neighborhood absorbs the damage. That strategy dismantles our historic framework, undermines our watershed protections, and sets a precedent that opens a Pandora's box for future developers. Our neighborhood is already under siege. A 30-story tower to the east, a 400-person venue, party event venue to the south, and now this. Land is already assessed at twice the value of our homes. If this project is approved, modest single-family houses will give way to townhouse profit margins, forever altering our character. You can look at the page with all the pictures on it of the neighborhood and stuff. The solution here is clear and simple. Require the applicant to respect the existing lot lines and setbacks, just as our neighbors have done since 1907. If they truly valued this community, they would design 4 houses on 4 lots, not 6 townhouses using a recombination scheme. In summary, we ask this committee, recognize and respect the history that defines our neighborhood. Don't be swayed by half-truths and omissions. And more importantly, don't rewrite history. The final diagram, that last page you have, how do I do this? There, needs no explanation. RHDC guideline 3.3.7 could not be more clear. Sensitive projects in historic neighborhoods can add value when they respect context and comply with guidelines. This one does not.
Are there additional members of the public who wish to, please come forward.
I'd like to cross-examine the witness.
Hold on just a second. Let me defer with, is that permissible?
It is permissible,
Okay.
yes.
Mr.
Reese?
Yes, Mr. Reese. Sorry, I'm blanking on your name. Please come back forward.
Thank you. I have just a couple of questions for you.
Is she allowed to do this?
Yes.
Cross-examine?
Okay. Cross-examine. We've gone that far. Okay, go ahead.
It's a quasi-judicial procedure.
Yes, I know.
Okay.
Lovely.
All right. I just wanted to get some clarification. So I believe I heard that you felt that the variance process was being sidestepped. What variance would be required for this approval?
For you all to build these townhomes as you have, you would have to recombine these lots. Because right now, these lot lines split one of the existing townhouses. You would not be able to sell that townhouse because it's on 2 different lots.
Is recombination the same as a variance?
No.
All right. Also, could you please let us know your experience and education with respect to stormwater?
I've been an architect and worked with stormwater management folks for 30 years.
Thank you.
Yeah.
To rebut, I'll just quickly note that recombination of lots in North Carolina is an exempt plat. Thank you.
Noted. Are there any additional members of the public who'd like to provide? Yes, please come forward.
My name is Kathleen McQuaid. I live at 802 Brooklyn Street.
Please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
I do.
You may proceed.
I don't know why my house was not included. We're at the top end or the bottom end of the block to the east, and it was not shown in pink. There are two one-story houses between Clay Street and Gaston Street, in addition to our one-story house. Oh, it's not contributing because it's too far?
Ma'am, please just make your comments to the committee. If you'd like
Well,
to have a
there are
discussion.
three houses.
Ma'am, please make your comments to the committee. Direct your comments to the committee. If you have questions about process or procedure, please direct those to staff who can address those after today's meeting. If you have
Okay.
comments on the application, please direct those to the committee.
Yes, I think this is a completely inappropriate design. I live on the street on the very next block. Our house is one of three one-story houses with porches that are either substantial or extend across the entire front of each house. The two-story apartment building is across the street from me. That's been there quite a while. My house was designed and built sometime around 32, 35 years ago, but it was built to fit in to the neighborhood. I think that's completely being overlooked. This three-story design scheme is more appropriate for a true downtown location or a bigger city at best. They're just incompatible with the neighborhood. And our neighborhood is under constant attack with rezoning requests, variances, et cetera, that are chipping away at the integrity of our historic neighborhood that I really feel needs to be respected. And I also am a licensed architect. Any questions?
I'd like to provide a short rebuttal. With respect to the porches that extend all the way across the structure, we did provide evidence last time and in our application showing some examples that are contributing structures that do have a narrower porch design. Also, I believe we've just heard testimony related to a general dislike of the design as well as a dislike of some other projects unrelated to this one. So I'd like to ensure that especially the testimony related to other projects besides this one be stricken from the record. Thank
The
you.
motion's granted.
Thank you.
Are there any additional members of the public who'd like to provide comment? Please state your name.
My name is Janine Grissom, and I live at 715 Gaston Street.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes.
You may proceed.
I've lived on Gaston Street my entire life, and so I've had the ability to watch how stormwater management, which we don't have in our neighborhood, how the stormwater affects the houses on Gaston Street on the west side. And over the years, before the parking lot was put on Brooklyn Street, we didn't really have any water problems in the backyards, but we all gardened. There were 4 houses that had vegetable gardens in their backyard. I was one, and my grandfather next door was another one. Anyway, after the parking lot was built, they regraded the land so that it sloped down to the southeast corner of the lot. And all of a sudden, we started having water coming into the backyard. So we all dug ditches that ran through the neighborhood and ran down to the P Street Market, which has the tunnel that takes it to the city's stormwater management. That's the only way that water gets there is through these avenues. Well, the ditches worked. They worked fine until they built the condos and the apartments. And the water from those two things now floods our backyards. You know, the ditches aren't containing the water. So adding more structures across the street, even though they say they're going to address the water issues, I don't know how that's really going. I'd like to make sure that's going to happen because I'm already flooded. And I don't need any more. I mean, I've got pictures to show all the flooding in my backyard and my mom's backyard next door. Anyway, that's one of my problems. The other is that back in '84, we rezoned the neighborhood to try to preserve the existing historic structures. And so I really had I have a lot of experience with what's been built and what exists in our neighborhood. And we've never had anything of this magnitude. We've never had townhomes, that's for sure, and nothing this tall. I mean, the biggest ones are 1.5 stories, but the majority of the houses in the neighborhood are 1 story. And then there's some 1.5 stories. There was another issue, and because I'm not good at doing this, I'm forgetting what it was. Oh, it's the traffic. The other thing we have is, since they built the apartments, Gaston Street's become a speedway. It's just inundated with traffic. Adding this much more density is just going to add just the turbulence that we're experiencing in the neighborhood because all of our streets are narrow.
Objection for non-expert opinion on the traffic.
Motion is sustained.
Anyway, I live with the traffic, so that's, yeah, I mean, my biggest issue is the appearance. It just doesn't fit into the neighborhood. And we really have worked hard to preserve the houses there. And we've done a good job since '84 when we rezoned the neighborhood. We didn't lose any houses. The only thing that happened was the church was torn down and 3 houses were built where that church had been, and they did a good job of fitting in, but that was on Glenwood Avenue. But by and large, the housing doesn't have anything this tall at all. But anyway, thank you for listening.
Just a short rebuttal. With respect to the stormwater issues that we've heard, all of those pertain to what exists today. We are proposing something new, something that we're working with the city with respect to stormwater. Over time, stormwater regulations have only grown far more stringent than they've been in the past. With respect to the need to preserve existing structures, just want to remind the committee that for purposes of this review, the site is considered vacant. The demolition has been approved. Also, we have provided evidence previously of many structures that exceed 1.5 stories in height, including some 2.5-story structures as well. Thank you.
Are there additional members of the public who'd like to provide comment on the application? All right, seeing none, we will proceed with committee questions of the applicant.
Questions for the applicant right now?
Or witnesses if you want.
Yeah, okay. This question is for the applicant. Molly Stewart, please. So could you, I missed a little bit of the conversation you had with one of the neighbors. Could you repeat what you said about, I believe you mentioned that recombinations are exempt. Could you repeat that
They're
statement?
an exempt plat in
Okay.
North Carolina, so not subject to sort of subdivision review.
Okay, thank you.
Thank you. I'm sorry? Recombination plats don't go through a standard subdivision review process.
Molly, I'm going to ask you to ignore the questions from the audience and just direct your comments and answer questions from us. And I will note that your point is correct.
Thank you.
Okay. And then I know you said you clarified the heights, and I appreciate the new materials that were provided. I feel like I heard a few different heights for the proposed structure, and could you just repeat which height
Sure.
it will be? And I guess for the sake of this, to the ridge line, is that or were you?
I will.
were you-
I will state what I have and allow David to correct me if I'm wrong. I believe it is 36 feet 9.5 inches. Nope, I'm sorry, 37. 37 feet 9.5 inches.
And that's above finished floor or from grade?
From sidewalk. No, we have a different number for sidewalk. There's sidewalk and grade.
Two different numbers. There's one from sidewalk. I think this latest plan here has it. Oh, it's got most of it.
I'm going to go back to my slides. There's any good. Thank you.
I'm afraid I'll mess this all up.
And you passed out some new. The reason I mention it is because I feel like the papers you passed out are the intended height, right? Is that correct? The exhibits that were passed out.
No, we pulled those. Okay. Oh, this is the one, right? 37?
Yeah.
Those the right numbers?
Yeah, 37 9.5. That's from the finished floor, and 42 5 inches is from the sidewalk.
Okay,
Yeah.
got it. And I don't know that it was listed, but I feel like you may have mentioned in the hearing or in your presentation the apartment building across the street. I realize it's non-contributing, but it is in the district. I think you stated a height, and I know it's speculative, but unless you had it surveyed.
It is not speculative. We have that from its
Yeah.
COA. So 36 feet 4 inches for the
Okay.
duplex units.
Okay, thank you.
Sure.
That's my questions for now.
Can I make a note about the staff report that is provided for the 809 and 813 Brooklyn Street application is from the initial submittal. It is important to note that the applicants for that case revised their submittal at their second meeting, and that was not reflected in a staff report. I don't recall if they changed the height as part of that application or those changes, but the staff report reflects their first version, not the final approved version.
My apologies on that. This is the public record that we have.
Sorry.
Understood. And I do have one more question. Sorry, y'all. Is the rear porch still proposed to be screened? It looked like the elevations were maybe slightly graphically different this time.
Yeah, they haven't changed.
Okay.
They're still proposed to be screened.
Okay, thank you. I don't have any other questions right now.
I have a question for staff. Colette, the staff report that we're talking about that was submitted for evidence, was that approved, that height?
The project was approved. I do not know or remember if the height changed in their revisions. This staff report reflects a previous design that included two structures, one in front of the other.
Mm-hmm.
It was revised at a COA meeting. A staff report was not created because the revisions were happening during the meeting to include two structures side by side.
So the 30s,
It may be the same height.
I see.
It
Okay,
may
but you
have
don't know.
changed.
Okay.
I reckon, yeah.
We withdraw it as evidence.
Yeah. Okay.
Thank you.
Motion is granted.
I have a question for the applicant. The newly printed materials here, is the street massing setback study the same as the frontage occupancy study? And if
No.
not, could you
Sure.
describe how they're different?
Sure,
Because-
absolutely. The setbacks are are just that, right? Showing you the difference between the building and the right-of-way line. The occupancy, the frontage occupancy, is a percentage. It's how much of the width of the lot is occupied by a building. So it's the ratio of the building width to the lot width.
That makes sense.
Right, but, I mean, okay. And I guess the follow-up question would be, is it your contention that those numbers are the same? Because all of the numbers on this sheet, the frontage occupancy match the setback massing study numbers.
David, can you address this?
Can I see what he's looking at?
Sure. Yeah, I think maybe it's just.
You said the frontage was in July or the?
Yeah, there were two studies done. One was the setback from the street, the other one was.
They were included in the July
Yeah.
submittal.
Okay.
Yeah, I think there were two versions of this drawing, and the one was issued, looked just like this, that I sent to Molly, and I noticed that this title was incorrect, so I corrected it and sent her a new title on it. And I think that that's where the error is in the title of the drawing, not the information contained within it.
So, I guess.
So this drawing that you have here, that's
This one.
matching, yeah, this is the percentage of the width of the structure itself in relation to the width of the lot.
Okay.
So the street massing setback study, the title itself is what's incorrect, not the information contained within it.
And this is new information compared to the actual street massing setback
Correct.
study.
Yes.
Got it.
We use the map as the jump point for new information, right?
I think that's my only question.
Any additional questions for the applicant?
Yes, I do. Whoever would like to answer. It's in regards to the points that have been made in regards to unnecessary hardship. The HODG, which we are in a street side overlay district here, but it was provided in our evidence, so I'll refer to it. Refers to compliance with historic development standards that would cause unusual and unnecessary hardship on the property owner, which is the part that is underlined, but it continues beyond that, which other property owners in the overlay district or historical landmarks would meet. I would love to hear some more detail on what the owner believes are the hardships beyond for these sites specifically that are held beyond other historic properties in this district.
Sure. First, a quick clarification. That section, that language is from the HODG section.
Yes.
It's not duplicated in the street side section, but it
Sure.
is referred to.
Right.
So it is made applicable. So I wasn't sure how to label that without being misleading in one way or another.
Sure.
So in any event, it does apply. But with respect to hardship, it is simply a challenge, right? To figure out how to build in an area like this where you've got the 5 stories, you've got the 1.5 stories, you've got 2.5 across the street. How do you make that a house that someone wants to live in? Obviously, one can build anything, right? But to build a house that is useful and functional in the world that's around it, it's a matter of transitioning, and it's something that we hear over and over again in procedures like this one, in rezoning procedures. It's a matter of making sure that you're able to do something that's in the middle, and it's extraordinarily hard in this location versus any a more central location in the district that has more of an intact character around it.
Okay. The other, I think the I would like a little bit of clarity on why we are not seeing any reference to the heights of these well-related contributing buildings that are, you did refer to on numerous occasions that these were not close, but then the examples of contributing structures you're giving us are blocks and blocks away from this. So there are contributing structures within a well-related distance.
Absolutely.
Just probably not the height that I imagine
That's
you're
exactly
after.
right. That's why they're not there, because, you know, if we're looking to meet this 10%, those are not there within that block and a half. Yeah.
Right. That was all. Thank you.
Thank you.
Any additional questions from the committee? All right, hearing none, we'll close the evidentiary hearing and move the matter to the table for committee discussion. Go ahead, Laura.
So I've been thinking deeply about this one. I do, you know, as an architect, see the reality of the location of this lot, and in function, I find this application to essentially, without doing so, try to remove this lot from the district. It is creating, it's proposing height which is not congruous. It is, while the detailing potentially could be found congruous on a structure that was more appropriate in scale and in height, the evidence provided here, and there is much evidence, I don't find it supportive of this lot. And the guidelines do not ask us to consider boundary lots differently than we consider those at the heart of the district. In fact, doing so would continue to chip away at the boundaries of our districts, and there are other methods to do that. If you wanted lots removed from the boundaries of the district and functionally make your lot part of something that it was not meant to be in the first place, then there are other ways to do that. So for me, height is one of the guidelines. For this one, it is not to pun, but it's a big one. So that's me.
Any additional comments from the committee? Rob, anything? Jordan? No. Melissa?
Yes. Just going back to the special character of the Glenwood-Brooklyn district, I think there are things that this project does that do adhere, such as it being in the style of a craftsman bungalow. We see large dormers that expand the upstairs living space, double hung windows with an upper sash composed of 3 or more vertical panes. So I do think that there has been some effort made to make this building relatable. However, I think agreeing with Lauren that there are glaring issues that are not congruous with the district. And referencing again the special character of the Glenwood-Brooklyn district, as a rule, houses on the Brooklyn section west of Glenwood Avenue tend to be smaller and more modest, with simpler stylistic expressions and a greater number of vernacular forms. It also talks about bungalows mainly being 1 and 1.5 stories up to 2 stories. And this at 2.5 stories, I don't think we've seen any evidence of any well-related nearby buildings that are within 10%.
Any further comments? Jordan, you had your hand raised.
Yeah, I was just going to say, I think Lauren's question and the applicant's response to it is somewhat illustrative, but, about finding, or the examples provided in the materials and their, proximity to the applicant's site, and just how, and I'm not sure if Glenwood-Brooklyn is one where we've determined a radius for nearby and well-related. I know in some it's 1.5 blocks, but just how there are very few contributing structures within that radius to support the scale and massing of this proposed project. And yeah, that's really all I have.
All right. Rob, any comments?
Not at this time.
Okay. I'm going to invite the applicant up just briefly. You've heard the comments, the discussion of the committee. We try to work with applicants if there's a possibility of something being proposed that can be workable. In that case, we could further defer the application. But based on the comments of the committee, it appears that height is an issue for the committee, and that seems like denial would be also on the table. So I want to provide the applicant opportunity. If you think there's a way that you can provide an amended application that this committee could approve, then we could defer the application. But if not, it looks like we're headed toward denial.
To understand how to answer that question, we would need to understand the concerns. Some of the comments that we've heard are that the structures that have heights within 10% of the height proposed are not within a block and a half, or not going to meet that standard. So what we've heard is really just focusing on that 10% generally should guideline without giving weight to any sort of special conditions that might exist here. If we need to meet that within 10% of contributing structures within a block and a half, that's going to be a very short structure. We may need to confer for a couple of minutes.
Sure.
If that, I think that's what we're being asked. If that's not the case, I'd love to hear that.
I mean, I can let the other committee members speak for themselves, but that did appear to be a big concern, given that the properties within the 1.5 block radius, there are none within 10% of the height of the proposed structure.
Is the standard I'm hearing that they must meet 10% of the height of?
As you stated, it's generally.
Okay.
I'll defer to Patrick.
Yeah, I don't think the committee needs to articulate a particular standard or objective measurement, and I would encourage you to steer away from that.
So if you'd like some time to defer, we can recess for 5 minutes and then come back.
Yes, thank you.
Sure. The committee will be in recess for 5 minutes. will come back to order. Before I recognize the applicant, I recognize Patrick for a comment on the committee's congruity analysis.
If I may, and this is simply for general context as a bit of a reminder of the incongruity standard that's been set forth by the courts of the state of North Carolina. And I have a passage here from one of the decisions, Mears v. Beaufort, but there are other cases that cover the same ground. So the standard that we're all working with comes out of this. The commission shall take no action which would be incongruous with the special character of the landmark or district. The Supreme Court interpreted this phrase to be a contextual standard. The standard of incongruity must derive its meaning, if any, from the total physical environment of the historic district. And that's it in a nutshell.
Thank you, Patrick. I recognize the applicant.
Thank you, committee members and counselor. That is very helpful context, and I think it may change that analysis we have provided, height data within the context of the historic district as a whole that supports the height requested here today. Although we were conferring on another matter, I think we would need to understand how that changes the comments that we heard.
Is that your comment?
It is a question because we've had new information introduced, and so it diverges from what we heard as far as the importance of that 10% within a block and a half. And what we just heard is that we do need to look at the entire district.
Yes, thank you. That is the standard that has applied throughout the entire hearing. So I think I recognize and appreciate your comments about that. So do you have anything else, or was there any questions from the committee for the applicant? All right, hearing none. Thank you.
Okay. Well, we still have our answer for you as well.
Okay,
yeah,
sorry.
Which is that we would request additional time, although we remain at this point a little bit uncertain as to the significance of the block and a half. We are going to go back and consider what could be brought back.
Okay, thank you.
Thank you.
We'll reclose the evidentiary hearing and bring the matter back to the table for further committee discussion. Any other discussion?
One thing that we haven't discussed is the open area to built mass. And I know that there's the frontage occupancy that was provided, but I still don't see any visual evidence to support the two building masses from the street frontage and being congruous with where it's located in the district.
Any further comments?
I'll just say, Melissa, I think there was this exhibit which I think attempted to show front percentage,
right,
just for frontage though, and not total
mass. Right.
Yeah.
That's why I think in the past what we've seen that's helpful is like an elevation or something where the evidence is more visual in nature, and we can see the overall mass, not just from a percentage.
Any additional comments from the committee? All right. Hearing none, I move that the matter be deferred to the September 25th meeting of the COA committee. Is there a second?
Second.
Any discussion or debate on the motion? All those in favor say aye.
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 Any opposed? Motion carries unanimously. All right, the next matter on today's agenda is COA 91-2025, 415 North Boundary Street. While the applicant is making their way to the dais, I recognize staff for their presentation. Give them time to set up.
I'll send you, make sure you have the recording and everything. I'll make sure you have the recording and everything.
All right, this is case COA 91-2025 at 415 North Boundary Street in the Oakwood Historic District. The request is a partial after the fact to install artificial turf and remove concrete driveway strips. This is a view of the existing primary structure on the lot and the side yard with garage structure and those driveway strips that are a part of the work request. Looking toward the rear, some existing artificial turf. We mentioned this is partially after the fact. The proposed request does not reflect what's on the ground in these photos. So I'll direct you to the application materials for that. Some lower yard, side yard, and looking back toward the street. And the rear yard looking to the west and back to the east. I'll note the fence line that this photo is staring directly down is the property line, so this request is only for installation of artificial turf on the subject property. So left of that fence line is a separate property that would not be granted approval through this application. And a view from the side street on East Street. Summary of staff concerns were evidence to support the congruity of artificial turf was not provided as a material. Evidence to support the extent of the proposed material on the site was not provided. Evidence demonstrating the inability to grow organic matter or handle the stormwater concerns on the site through other means was not provided. Reversibility of the installation may be difficult, and evidence to support the congruity of a garage-like structure without a driveway connection was not provided. And the applicant has a presentation and some additional evidence to pass out, so let me get this set up and we'll hand it over.
While we're doing that, go ahead and introduce yourself, please.
Yeah, I'm Jerry Steifelman, co-owner of 415 North Boundary Street.
All right, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Yeah, thanks.
Oh, here we go. Okay, so if you just scroll up and down, it is slow to respond, but it should listen to you. There you go.
I'm mostly going to read, but if there's something someone wants to see, tell me, and I will scroll to that page. Since moving to Historic Oakwood in 2021, we've applied for and received COA approvals for awnings, for paint colors, for solar panels, and fencing. When we installed synthetic turf, we didn't realize that a COA was required. We first learned of the RHDC's concerns when staff visited our property during our initial solar panel application. Since then, we've gone out of our way to work with the commission and staff. We've removed all the turf in front of our garage and most of the turf to the east of the garage and replaced that with natural grass, and that was in the photos that Aaron showed. We removed gravel in front of the garage at the staff suggestion and replaced that with natural grass. We've installed fencing on both sides of the garage to fully obscure the synthetic turf from street view. And with this application, we're seeking to remove all the synthetic turf on the west side of the garage. This is our third time before the commission. We're going through this trouble because our little turfed area is something we use every day. It's a big part of our lives. I apologize, there's a mistake here. I had transposed the wrong number. It's not 696 square feet, it's 607 square feet. All we're asking is to retain that 607 square feet of turf located behind our garage and house. This allows us to use that portion of our small yard for exercising with our dogs. The commission has a clear precedent of permitting historically incongruous features such as swimming pools, plastic play sets, raised patios, and modern additions when they're obscured from view and support the livability of residents. With respect, denying this application would amount to singling out one feature while allowing others, in contradiction to the state's own guidance. In terms of that guidance, we'd like to cite directly from the Handbook for the Historic Commissions of North Carolina, published by the State Preservation Office. I'm quoting, "The guidelines should be detailed and specific enough to protect recognized values of historical resources, yet flexible enough to accommodate unusual situations and changing circumstances. The guidelines should also take into account durability of material and the needs of property owners, as well as aesthetic considerations. This guidance creates a clear space for the Commission to approve our application. Our circumstances are indeed unusual. We must make do with a small, irregular yard on the site of what was once a grocery store. The yard is shaded and subject to significant water runoff because our section of North Boundary Street was historically an open water channel. We learned this from the City of Raleigh stormwater engineers after a house was flooded during repairs to a water junction box adjacent to our property. During that process, engineers discovered an unrecorded 36-inch historic drainage pipe located directly under our house. This is the same issue. This is why the city is scheduled to dig in front of our garage in 2026, which is how those driveway steps would be removed. As there's no mention of artificial turf in the guidelines, we ask what it can reasonably be compared to. We appreciate the Commission's commitment to protecting the character and the integrity of Raleigh's historic districts. We recognize the responsibility inherent in preserving a shared architectural and cultural legacy. At the same time, we respectfully ask the Commission to consider a more appropriate and context-sensitive interpretation of the request. In earlier remarks, staff classified our turf installation as most appropriately reviewed under the category of surface-level paving treatment. While we understand the intent of the guidelines reference to prevent the overpaving and hardscaping of residential yards, this classification misunderstands the purpose, the appearance, and the functional qualities of the turf as it applies to our property. Artificial turf is neither a paving material nor used in this case for aesthetic display or for passive gathering. It's not analogous to brick or stone or gravel or concrete. Instead, it's a recreational surface installed in a defined side yard where our dogs and ourselves can safely exercise. The guidelines do offer a more fitting functional precedent, considering artificial turf as a form of contemporary equipment or incompatible site feature as described in Guideline 1.3.11, which I'll quote from. Introduce contemporary equipment or incompatible site features, including satellite dishes, playground equipment, mechanical units, and swimming pools in locations that do not compromise the historic character of the building, site, or district. Locate such features unobtrusively and screen them from view. End quote. This provision doesn't seek to eliminate all modern features from the district, but to manage their placement and visual impact. Our installation fully adheres to this principle. Our turf is located and our house is kind of unusual, so our side and rear yard are the same, so it's located there away from street view. It is screened and unobtrusive, not compromising the visible historic character of our property or the district. I should note that in the photographs that Erin took, our gate was open at that point, but when the gate closes, the turf is not visible at all. It serves a purpose akin to playgrounds, which are explicitly permitted by enabling, which are explicitly permitted because it enables safe, hygienic activity for our pets and ourselves, a meaningful aspect of contemporary residential life. And the turf is not permanent. As we've shown already, it can easily be removed because as we've done, all the turf in front of our house and most of it on the east side has been removed. If the Commission has previously allowed pools, trampolines, playground equipment, air conditioning units, trash enclosures, and satellite dishes to exist within the district, subject to reasonable screening, then it has acknowledged the need to make space for modern life. We believe our turf aligns with this same principle of pragmatic compatibility. We respectfully request that the Commission evaluate our application under the more appropriate framework provided by Guideline 1.3.11 as discrete and purposeful modern feature that enables contemporary life while preserving the visible integrity and character of the district. And then we have some additions to address the staff concerns. One note is we've consistently acted to address the Commission's returns. The request is now limited and modest to retain turf only in a screened rear yard where no historic features were removed and natural ground cover cannot be maintained. The guidelines themselves state, quoting again, "These design guidelines provide applicants, the Commission, and staff a basis from which to reach decisions and an assurance that consistent procedures and standards will be adhered to. We believe the handling of our case thus far has lacked the consistency required to fulfill the above promise." And so going to the staff concerns one by one, the first concern is that artificial turf is a manufactured surface not regularly found in the district, and we didn't provide evidence of congruity. However, our position is not that artificial turf is identical to ground cover or congruous, but that the guidelines provide room for modern features when provided consistently and reasonably. I'm going to go through a few specific key points because they seemed important to the staff concern. 131 says to retain and preserve building and landscape features that contribute to the overall historical character of the landmark or district. So you're not taking anything away. And 134 says do not replace missing or deteriorated historical site features with new features that are incompatible. In our situation, there is no loss of historic features. The turf was installed only over predominantly bare dirt and mud. No gardens, plantings, or historic site features were altered or removed. We covered dirt. We replaced nothing. 139 was cited, which is introduced compatible new features constructed of traditional materials only in locations and configurations that are characteristic of the historic district or landmark. No traditional materials were inappropriately added. The article discourages the practice of adding traditional materials where they did not historically exist. As an English major, I will tell you that as written, it refers only to the misplacement of traditional materials. It's not relevant to our COA at all. In 1312, it's not appropriate to introduce constructed features or objects that are similar in appearance, material, or scale to historic elements, but are stylistically anachronistic. This is a material versus stylistic distinction. Turf is modern in material, but it's not stylistically inaccurate. It allows for something that looks and functions like grass where grass cannot grow. At least in our case it does. A truer expression of an anachronism would be using a historic material, such as cement, in a non-historic fashion. Yet the Commission regularly allows end-to-end concrete driveways which are permanent and are impermeable, unlike our small area of turf, which is neither. Such driveways are approved despite the fact that the special essay for Oakwood specifically mentions driveways themselves are most often gravel or concrete ribbon strips. The next specific one cited was 155, which is design new walkways, driveways, or off-street parking to be compatible to locations, patterns, and other things congruous to the district. However, our turf is not our rear yard. It's not a walkway. It's not a driveway or a parking area. Unlike the clear direction on driveways, for which the Commission regularly grants flexibility, the Oakwood Character Essay is extremely open-ended in regards to rear yards. I will quote from that essay. Recent years have seen the development of increasingly more private rear yard spaces as a counterpoint to the public front porches, with the erection of many privacy fences and outdoor decks. Numerous buildings, garages, accessory buildings, and even a couple of barns dot the rear yards of properties throughout the district, end quote. I'll note that these two quotes are the only references to rear yards in the entire Oakwood Character Essay, pointing to the fact that rear yards are not key to the neighborhood's distinct character. Given the lack of direction and importance given to rear yards in this essay, we suggest our small, completely obscured area of permeable, removable turf is approvable under Article 1311. So for these reasons, it seems keeping turf in the rear yard yet obscured from view, which is all that's left now that we've taken the other away, is consistent with both the language and intent of the guidelines. The next staff concern was that the Merriam-Wynn House is outside of Oakwood and cannot be considered precedent. And for Merriam-Wynn, efforts were made to plant natural vegetation before the turf was applied. We recognize that Merriam-Wynn is not within the Oakwood overlay. However, both staff and commissioners have already treated it as a relevant comparison in our case. At our December 2024 hearing, commissioners directly referenced Merriam-Wynn as a comparable example when weighing our application. Staff reports have likewise invoked Merriam-Wynn. This selective use of precedent is inconsistent. If Merriam-Wynn can be cited to raise the bar for our evidence, it should also be acknowledged when it supports our request. And a few points in regards to Merriam-Wynn. At Merriam-Wynn, turf was approved for a large, highly visible event lawn. To my eye, that lawn is actually larger than the footprint of the actual structure. By contrast, our proposal concerns a modest, shaded rear yard screen from public view. If turf was permissible in that context, it is even more reasonable here. And in terms of hardship evidence, the turf installed at Merriam-Wynn is flat, it gets plenty of sun, not to mention it's an asset that earns millions of dollars in revenue. It makes sense in that instance to request scientific studies. Our yard is the opposite. It obviously holds water and is shaded. Commissioners acknowledged in December that unlike Miriam Wynn, our site's shade and drainage conditions make natural grass impractical. Those conditions remain unchanged. As well, we don't see any support in the Blunt Street character essay. The essay mentions no point of difference as to why a large area of turf is acceptable in Blunt Street overlay, yet not acceptable in the Oakwood overlay. In short, if a commercial scale, national landmark property was permitted turf for aesthetic and functional reasons, then a small screened residential yard with a documented hardship should not be held to a stricter standard. There was also a request in the staff concern for a different style of landscapes letter. That request directly referenced Miriam Wynn, which in other instances we're told can't be referenced. Our response to that is we're applying as homeowners, not as owners of a large business. We submitted a letter from a 20-year experienced landscaper confirming the obvious, that shaded yard at the bottom of the hill cannot maintain a lawn. I mean, said that landscaper, Donald Florence, has worked for us for 2012. So he was not only referencing the lawn as he saw it, but the way we use a lawn, because he's been with us through 3 different houses. This letter was accepted as competent evidence during the December 2024 hearings. At that time, commissioners themselves acknowledged that shade and drainage conditions prevent grass from growing in our yard. I'm quoting from Commissioner Woodard, quote, "Considering the site layout, you can see that any grass would be shaded out there, even without the use case of dogs. Requiring soil tests or additional studies imposes an unreasonable burden when commissioners already recognize the obvious site conditions. For comparison, Miriam Wynn House received approval despite being a large, sunlit, flat area where grass could have been expected to grow. Our yard covers 607 square feet, a shaded rear yard where natural ground cover is clearly impractical. Our yard is shaded and at the bottom of a grade in what was historically an open water channel. It's very clear that a lawn cannot be maintained here. The requirement for further evidence now, after evidence was accepted previously, is an example of shifting standards that undermines consistency." The next area, concern number 4 from staff, is built area and lot coverage. As expressed, artificial turf is akin to a larger paver patio or surface paving material, and saying that built-in area calculations were not provided. Also noting that our estimates differed from staff estimates. I think that's because of gravel. We respectfully note 3 points in response. 1, there has been a shifting framework here. In December 2024, staff treated turf as a materials issue. It was not considered a built issue. We were discussing appearance and texture. But in February 2025, staff reframed turf as a built area issue. This change introduced new evidentiary requirements, namely lot coverage calculations, that had not previously been required. There was no concern for built-to-area proportions requested of Miriam Wynn, despite their far more prominent use of turf. Staff's calculation includes gravel as built space. We can find no articles in the guidelines that define gravel in this way. But if gravel is determined to be problematic, we're willing to replace it with a treatment that the staff or this commission considers to be less built. Again, we're only concerned with this little piece of turf because it enables us to use our yard. And also offer historical commercial context. Our property is one of 4 historically commercial sites in Oakwood, all with unusually high built area to open ratios. If you look, you'll see the Lewis Cherry office, Side Street Cafe, and smokestacks. Those sites are almost entirely covered by their buildings, far more than ours. These proportions are themselves part of the historic character of such properties. Turf in our rear yard in this context is congruous. Finally, we emphasize that the scale of our turf is modest compared with other routinely approved features, pools, patios, and driveways, which cover larger surface areas and are far more permanent in nature. The 6th staff concern was visibility from the street. And that note is that the concept of visibility does not determine whether a change is congruous. We agree that visibility is not the sole factor in determining congruity. However, visibility is a long-standing and critical consideration in both the guidelines and the Commission's decisions. As we've noted before, Guideline 1311 explicitly allows modern features in rear yards when screened from view. Commission precedent demonstrates that pools, decks, playgrounds, and mechanical units are routinely approved when screened. These features are in many cases far more prominent, larger, and more visually obtrusive than our modest area of turf that we're trying to keep. And then referencing the character essay guidance, the Historic Oakwood Character Essay describes rear yards as spaces of privacy and diverse use, containing outbuildings, garages, and even barns. This language supports granting flexibility for practical screened yard features, such as removable turf that enables active use of the property. Thus, while visibility is not the only test, it is an essential and relevant one. In this case, the turf is fully screened from public view and is consistent with the district's own character description in that way. The staff also expressed concern with reversibility and soil compaction and chemical leaching. That concern is speculative and contradicted by our direct experience. We have demonstrated reversibility. The turf previously installed in our front yard, where we do have sun and more even draining, was removed and replaced with natural grass in approximately 3 hours. There's minimal alteration. Our product used is 1.57 inches. It's permeable, and I don't know if you've seen that we linked to a video where we pour a pitcher of water through the turf so one can see how permeable it is. It's laid over existing soil, and it doesn't alter grade or drainage in any permanent way. In fact, what we've found is it's helped our drainage. As noted, we have issues in our basement with flooding, and the turf is helping. So it's not only completely reversible, but we've demonstrated it so. And we specifically chose PFAS-free turf. We chose this specifically to avoid contamination. This whole thing came about because of our installing solar panels because of environmental concerns. I regularly do pro bono work for the Sierra Club and other environmental groups. We're not turf enthusiasts. We're just trying to use our backyard. And Section 8 here is we wanted to talk about process inconsistency and reversal. While our responses above address staff concerns directly, we think it's also important for the record to reflect the broader process inconsistencies that have affected our application. One is the reversal between hearings. At the December 12th, 2024 evidentiary hearing, commissioners expressed a willingness to approve turf in the rear yard. I'll quote here from Commissioner Tripp. "We do have an example where it was installed at the back of Miriam Wynn House. Here you have similarities. You have a property where how it's situated, it limits vegetation, growth, and water pools. We do have a landscape professional who provided a letter giving his opinion that this area is difficult to grow grass. If you couch it in these circumstances of these cases, recognizing that it's a small area, how it's sited, the testimony includes pooling water and difficulty growing things, and that it's not viewable from the street, these are the reasons I lean toward allowing it." And a second quote from Commissioner Tripp. "Overall, I like the changes that were made to the more visible west side of the property. I don't have a problem with keeping the turf in the rear. It allows the property owner to use their backyard as they desire, and it's not visible from the street." And then quoting from Commissioner Woodard. "Considering the site layout, you can see that any grass would be shaded out there even without the use case of dogs." By contrast, at the February 2025 hearing, the same commissioners reversed their position. Again, quoting from Commissioner Tripp, "I'm a no on this. The Miriam Wynn House is not in the Oakwood District and cannot be used as precedent in this application. This shift occurred without any change in site conditions or the evidence presented." The other thing we wanted to mention is shifting staff rationales. In December, staff analyzed turf as a materials case, focusing on appearance. By February, turf was reframed as a built area with new evidentiary burdens, cover calculations, and soil testing introduced mid-process. This change in framework deprived us of consistent and predictable standards. And 3 is a selective use of precedent. Miriam Wynn House was cited by commissioners in December as a relevant comparison, and more recently referenced in the staff's own report, while suggesting we employ a landscape consultant more like the bigger firm used by Miriam Wynn. This inconsistent treatment of this precedent demonstrates selective treatment rather than the consistency promised in the guidelines and by the state. And just referencing again this disregard of accepted evidence, a professional landscaper's letter from a landscaper we've used since 2012 with 20 years of experience was accepted into evidence in December and relied upon by commissioners at that time. In the most recent application, the same letter was dismissed as insufficient and new evidentiary burdens were suggested. We understand the difference, the reason not to reference other districts in terms of congruity, but we'd like to reference an approval in another district not as evidence of congruousness, but as evidence of inconsistency in the application of the guidelines and unequal treatment in regard to livability by the Commission. Again, I'll quote from the Handbook for Historic Commissions of North Carolina from the State Historic Preservation Office. Procedural safeguards are needed to ensure that the Commission applies its authority evenly and to protect the rights of individuals as required by due process and equal protection clauses of the U.S. Constitution, by equivalent language in North Carolina's Constitution, and by the general statutes of North Carolina. The Commission's procedures must conform with the rules developed by the North Carolina Supreme Court for all quasi-judiciary judicial bodies to ensure due process and equal protection. These are the same rigorous standards and rules that must be followed by such bodies as city councils and Board of Adjustments. At times, staff asserts that applicants may not reference decisions outside the Oakwood district because each district is distinct. At other times, staff themselves invoke outside precedents when convenient. The selective conduct underscores the absence of consistent standards and treatment. The case we were referencing is the Commission approved paving over a large natural lawn area for 909 Oberlin to create a concrete turnaround for vehicles. When we emailed staff to ask about this apparent contradiction with concern over our turf, the response is that we could not reference it because it was outside the district. Yet the Oberlin character essay explicitly states driveways are generally unpaved. By comparison, the historic Oakwood character essay emphasizes rear yards as private and diverse spaces, which at a minimum is neutral toward our application and arguably supportive over it. In joining the approval of the driveway, in direct contradiction to the Oberlin Village character essay, Commissioner Lee explained, quote, "This is a busy street. I can understand the need for a driveway and why you would want to have a turnaround space in the rear. I think it has to have a driveway for livability, the way the house is designed on the lot." In one instance, the Commission accepts an incongruous feature, one which is far more conspicuous and permanent than ours, for the convenience of turning a motor vehicle around one's property rather than on the street. Yet in our case, the Commission has chosen to minimize the livability needs of our backyard, even though our small area of synthetic turf is obscured, it is permeable, and it is removable. So in conclusion, our request is modest. To retain turf in a small, shaded rear yard where natural grass cannot grow and is screened from public view. The record now shows that commissioners expressed support in December, then reversed themselves in February without new evidence. Staff reframed the issue mid-process from materials to built area. Precedent was cited when convenient and then declared irrelevant. Competence evidence was first accepted and then later questioned. These conditions raise serious concerns about the consistency and fairness of the process. We respectfully request approval of our COA 0019-2025. Should approval be denied, the record will demonstrate capricious and arbitrary decision-making and unequal treatment of our application. Thank you.
Thank you. Are there members of the public who wish to provide comment on the application? Seeing none, we'll proceed with committee questions.
Yeah, I'll start. I appreciate you coming back and sharing your thoughts. I'm going to ask a few questions that I think I asked at the prior hearing with your prior application. Were there any materials considered other than grass?
We first worked with mulch, but we kept getting runoff. It just kept going away.
Okay. Is there evidence of turf in your historic district?
Not that I know of.
Okay. I don't have any other questions.
Any additional questions from the committee?
Sure. Yes. Thank you again for coming back to see us. I just wanted to clarify your numbers here, just so that I'm clear on what the request is, since it's a removal of an existing, and how much we're talking about. So I'm seeing 141 square feet. Is that the amount of turf you're trying to get rid of?
No, that's the turf on the west side of our garage that we're asking if we can pull up and just keep the stuff in the back, which is...
And just to clarify, the turf is after the fact?
Yes.
So the request is to add the amount that they would like, not to remove an amount that exists now. So it's viewed as though the request hasn't been completed yet.
Yes, in concept, but in the application, it does say removal of turf, so it's a little unclear.
In terms of your legal review,
Yeah.
it's just looking at the total location of the final request.
Got you. And to confirm, your total amount is 607, I believe you said?
Yes.
Okay.
Yeah.
Thank you. All right. I think that was me. Thank you.
Any additional questions from the committee? All right, hearing none, we'll close the evidentiary hearing and move to committee discussion. Thank you, sir. You can have a seat. All right, I'll begin this this application, or an application very similar to this was before us in February, also after the fact, to install artificial turf. That application was denied for various reasons. All of those same reasons are stated in today's staff report. The application before us is to install artificial turf. The guidelines have not changed. Our interpretation of those guidelines have not changed. There is no reason to grant this application. Is there any other discussion?
No, not for me.
Jordan? Melissa? Lauren? All right. Based on the reasons stated in the staff report and based on the evidence presented at today's hearing, I move that the application be denied. Is there a second?
Second.
All those in favor say aye. Aye. Any opposed? Aye. Motion carries unanimously. Thank you. Next is COA 99-2025, 401 Kinsey Street. While the applicant's making their way down, I recognize staff for their presentation. Please introduce yourself.
Good evening. My name is Amy Kraut. I'm an attorney at Smith Anderson. I'm here on behalf of the applicant. We do have one witness that we'd like to swear in and tender as an expert.
All right, let's go ahead and I'll go ahead and swear him in. Please introduce yourself.
My name is John Zellweger. I'm with Provision Studio. I'm a resident at 603 Holden Street.
Okay, I'll go ahead and swear you in first, and then we can do all the qualification stuff later. Do you solemnly swear or affirm the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
I do.
All right, you may proceed. Or I'm sorry, no, not yet. I'll recognize staff for their report, and then I'll turn things over to the applicant.
Thank you. So as you mentioned, this is KCOA 99-2025 for 401 Kinsey Street. It is located in the Boylan Heights Historic District, and the nature of the request is to construct an accessory structure. You can see here a view from Kinsey Street looking at the subject property. And this view is from the side yard, kind of at the end of where that driveway was, looking into the rear yard. This is a view of the rear yard where the proposed structure is to be located. And again, from that same area, looking back towards the house. The rear wall of the structure and the north side. An abbreviated summary of staff concerns is the shallow garage bay. This is just an atypical design that staff has called out for you, and standard material details and specifications that are typically provided as conditions.
Now I recognize the applicant for their presentation.
Yes, first I'm just going to have Mr. Zellweger introduce himself and state his qualifications, and then I'd like to tender him as an expert.
Thanks. Good evening. John Zellweger with Provision Studio. I am an architect here in Raleigh. I've been registered since 2006 in the state of North Carolina. I've been a resident since 1997. That's enough on qualifications, right? Okay.
I'd like to tender him as an expert witness in architecture and design.
Without objection, so moved.
Thank you. With that, I'm going to turn over the presentation to him.
Thank you very much for seeing us this evening. We consider this a relatively straightforward and simple application, so I'm going to keep it short and then welcome your comments and questions. First off, as you can see, we have our attorney present because the house and property is in a trust. Our applicant is the daughter of the woman who has owned the property for several decades and has the intention of eventually being the sole owner with her husband. So this actual project is the start of an investment in the neighborhood with their ongoing life there. They are part of our music community. They have limited resources, and so we were charged with providing an economical structure that would also keep the design costs down. And so what we have here as our final resolution is what we believe is a reflection of that, which we think is congruous with the neighborhood, because many accessory structures were also very economical, simple four-walled structures that supported the life of the primary structure and the inhabitants. The conditions that were provided by staff or suggested as staff for the material information, the wall section, things like that. Happy to discuss them item by item, but we intentionally did not provide those as a conscious decision to minimize our time ahead of the application to ensure that if things were to move forward, that we were not wasting our time on a wild goose chase with some decisions on those choices, and that we could work with staff on making sure that those details were in fact correct. In short, as you see in the application, the intention is to match the house in almost all aspects. Everything from the roof slope, the roof material, overhangs, brackets, corner boards, trim around windows. All the notes indicate that the goal here is for the general contractor to work with the existing building as a prototype, to be able to use that as the guidepost for what the final building should look like. And so we think we are going to be successful meeting the staff requirements in that regard. That leaves the one comment regarding the front facade. And we think that this is sort of the nature of what we're doing here anyway. We're trying to find congruity with a new structure that is also not trying to replicate or, what's the term, prevent false historic appearances. And I think that that's an important fine line that we want to speak to. The goal here is to provide coverage over a front door that is actually asymmetrical, and we know that that's a little incongruous with the neighborhood. So the goal was to create a harmonious facade that front-faced and was pointing towards the street that would utilize existing precedent, but was also an interpretation for the 21st century contemporary use and needs of the building. The reason the door is offset is because of the contents of what the applicant intends on storing in there. They need as much linear wall space as possible without interruptions. And so that kind of was a driving factor. And so the idea was a creative interpretation of garage openings, taking advantage of some historic precedent that was from the historic period, as well as recently approved in the last 5 to 8 years, I believe, garage structures that are within the district. And so that's kind of it in a nutshell. I don't think I need to say much more, but I'm happy to kind of explicate any of the details, especially on the conditional stuff, lighting, mechanical systems, things like that.
Thank you. Anything else on the from the applicant's side for the presentation? Okay. Are there members of the public who wish to provide comment on the application? All right, seeing none, we'll proceed with any questions from the committee.
Hi, thanks for your application here. It's pretty clear. Is KDAT some sort of kiln-dried exterior timber?
That's correct. It's a treated lumber that doesn't utilize arsenic or any other toxic chemicals in the process, and it's more stable over the long term.
Got it. My second question, I think, is for staff. I didn't see it in any of your concerns or details, so I assume it's okay, but we have fiberglass windows and doors here. Like I said, I'm assuming that we have approved that in past presentations.
Yes, you have been approving fiberglass windows and doors on new construction and some accessory structures.
Okay. Those are all my questions.
Got a quick one. Can you speak to the intended use of those garage front bays? Is it actually going to be like a car partially in, partially out on that?
No,
Okay.
not at all. The driveway has been out of use for who knows how long. They don't pull the cars back there, and they don't intend to.
So it really is just kind of a nod to a garage bay door on the front of an
100%.
open space. Gotcha.
That's right.
So, and on that same kind of line of thinking, is there anything that would preclude having a door there instead of an opening?
Other than trying to be economical,
Sure. Okay.
I think that's the goal. I mean, we're talking probably $3,000 to $5,000 for some kind of garage door that is a false appearance in some way.
Sure. Sure. Okay. Thank you.
Thanks.
Any other questions from the committee? All right, we'll close the evidentiary hearing and proceed with committee discussion.
You all asked my 2 questions, so I did have 2 questions, and Lauren and Jordan asked them, so thank you for that. But yeah, it seems a little unusual, but I like the interpretation in a way of this as a porch, and I think to make them use garage doors could be theoretically creating a false appearance, and it seems like also against the desired use of that space. So I could see many ways it would be functional the way it's proposed. So
Yeah, I'd say
I don't take issue with it, and I think for the simplicity of the structure, it's a very nice design.
I agree. Its funkiness comes from it trying to be congruous, which I don't know if we can fault it for.
Yeah, I think, of the examples that they provided, I think it probably most closely resembles 606 South Boylan Avenue, where even though there is a car there, it's really sort of a open front shed, if you will, or a sort of lean-to type carport type situation. And, I don't think that the ability to park a car in this particular instance really affects its congruity. Yeah.
Any other discussion?
I'll make a motion to, based on the congruity analysis, staff concerns, previous similar applications, in the application presented here, I move to approve the application with the following conditions. 1, that detailed drawings and/or specifications be provided to and approved by staff prior to installation of construction. 1A, manufacturer specifications, including sections for the windows. 1B, manufacturer specifications, including section for the doors. 1C, stoop and railing construction drawings showing railing supports not attached to the band board. 1D, eave and soffit construction drawings. 1E, HVAC locations and details, if any. 1F, exterior lighting specifications and locations, if any. 1G, installation locations and specifications for the gutters and downspouts, if any.
Motion's been made to approve the application subject to the stated conditions. Is there a second?
Second.
All those in favor say aye.
Aye.
Any opposed? Motion carries unanimously. Congratulations. The application, the approval will be final after next month's meeting when the minutes are approved and signed. So, thank you. All right. How are we feeling? Are we good? Are we gonna keep going? All right. Next on the application, or next on the agenda, is COA 100 2025 105 Northeast Street. Ask the applicants to make their way forward to the dais, and I recognize staff for their presentation.
All right, as you said, this is case 100, 2025 for 105 Northeast. It is located in the Oakwood Historic District, and the nature of the request is to construct a rear 2-story addition and alter existing rear additions. This is a view of the property from Northeast Street. And this is another view from Northeast Street. Walking around, this is from the driveway looking towards the existing rear of the structure. Crossing beyond that fence that you just previously saw, this is a view into the side yard. A view from where that shed was in the previous photo, looking back towards the house. And a summary of staff concerns. Additional details are needed explaining how the new roof of the addition will meet the existing roof to preserve the slate. And I do believe that the applicant will provide additional information, but they are willing to add a condition to address this. And then standard material details and specifications that are typically provided as conditions.
All right, thank you. Please introduce yourself.
My name is David Griffith, and I'm the homeowner.
All right, and please raise your right hand. You solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth.
I do.
You may proceed.
So we set out to really try to make an addition that was as much congruous as possible, that really flowed seamlessly with the existing structure. Used the existing L in the back to build over, keeping within the setback and everything else. So right now, as it applies to the summary of staff concerns, we have not decided to start working with a contractor yet. We're in that phase. So therefore, I do not have a detailed roof plan as to how that's going to meet up with the existing slate. I do have some ideas of how that is done, and I've had some conversations with that. And with regards to preserving the slate, we would like to try to preserve as much usable slate as possible, especially if it can be used in areas where we might need to patch in during construction. And then also after the fact to have some on hand as we, if there are damage in the future to anywhere on the existing slate roof. And then as far as the material details and specifications, we put that in the application of what we would like to use. However, again, not having selected someone to work with, we don't have, the window cutaways and those kind of things to share yet.
All right. Anything else?
Nope. Thank you.
Okay. Are there members of the public who wish to provide comment on the application? All right. Seeing none, we'll proceed with questions of the committee.
Hi. Could you remind us what the front porch roof material is?
Architectural shingles.
Okay. And then the new hip roof on the back would also be architectural
Correct.
shingles. Okay.
It matches what covers the L at the moment.
Yeah, got it. And the only other question I had was you answered about just preserving the slate for future use and patching.
Ideally, we would like to do as little damage as possible, for the historic slate roof. But obviously, it's construction, and we know. But yeah, we would like to try to preserve anything that we can.
Yeah, I think there are probably a contractor would advise you on some accessories that could transition neatly between.
Yes, I've had some initial conversations, but nothing concrete to actually present.
Got it. That's all my questions.
Any other questions from the committee?
Only just because it's a little unclear from the drawings you have here, I guess the entirety of the normal, upper hip style roof is slate right now. Is kind of all of this new part going to be shingles?
The new part will be the architectural shingles that are on top of the existing rear addition.
Right, so where you have sort of ridge valley hip, that's the transition between
Correct.
shingle and-
Yep. Correct.
Okay, thank you.
Any other questions from the committee?
Yeah. I've got a couple, and you may have mentioned it, I'm sorry. But I'm noticing in your rear elevations for your addition, there's a pretty strong transition line reveal there that goes vertically and horizontally. Can you describe for me what that material is again?
All the material will be a fiber cement material.
Okay, so that like strong horizontal that wraps the corner of the back and then like turns down, that's also fiber cement? I might not be
I
understanding the
believe so. I think the reason for that was part of the denotation as to where the original L was at, and
Okay.
also how we kind of bumped in a little bit to denote the new construction on the back as well. So I think that's why he put that in there.
Okay. Let's see.
It may not stay. It might just be something that gets everything as hardy all the way across.
Okay, interesting. And then, yeah, I think that was it. Thank you.
Sure.
Any other questions? All right, seeing none, we'll close the evidentiary hearing and move to committee discussion. You can have a seat. Thank you.
I don't have anything to add.
Do we want the applicant has already agreed to it? Do we want to go ahead and condition the slate roof just as a precautionary measure? Or do we not?
I think it's a character defining feature,
Yeah,
but
I'm just trying to think
but
about
it's not in the application to remove it, right?
Right. I think what
Right. No, it's
we
not.
would potentially request is a detail that shows how the roof will transition from the new roof to the existing roof.
Right.
And that could just be added as one of the, like 1F.
I mean, that's already. It is.
Oh, it's already there.
Yeah.
Oh, good. Perfect.
Go ahead.
I make a motion that based on the application, the congruity analysis, staff concerns, and previous similar applications, to approve the application, subject to the following conditions. One, that the following be provided to and accepted by staff prior to installation or construction. 1A, a detailed roof plan drawing indicating the transition from asphalt to slate. 1B, manufacturer specifications including section for windows and doors. 1C, HVAC locations and screening if changing. 1D, gutters and downspouts locations and specifications if any. 1E, exterior lighting installation locations and specifications if any.
Motion's been made to approve the application subject to the stated conditions. Is there a second?
Second.
All those in favor say aye.
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 Any opposed? Motion carries unanimously. Congratulations. The approval will be final after next month's meeting when the minutes are approved and signed. Thank you. All right, the committee will take a 5-minute recess. That will actually be 5 minutes this time. ready to proceed with the next item on our agenda, COA 102-2025, 514 Method Road. I'll recognize staff for their presentation.
All right, this is case COA 102-2025 for 514 Method Road, the Barry O'Kelly School, Raleigh Historic Landmark. So I'll note the full campus here is a landmark, as well as the agricultural building independently, which is a part of the request, but layered historic landmarking here. So the request is to construct 2 accessory structures, alter the agricultural building's rear storefront opening, alter the existing stoop and install concrete ramping, also at the agricultural building, and replace a fence. This is the face of the agricultural building. So this is the north facade. Method Road is off to the left. So we're, fully within the middle of the park. This is the proposed fence for replacement on the west facade and some views of the existing windows. The rear facade to the south with the existing storefront that is also a part of the request, so a better view of that. And the east side toward Method Road. Some general contextual photographs of this area of the park. Generally, this photo is taken standing within relatively where the accessory structures are proposed, and then just some more contextual of the main community center, the historic gymnasium building, but no part of the major work request is related to this structure. No staff concerns. We will note some additional items that are shown in your application materials were previously approved as a minor work COA request, but the actual major work COA purview items are highlighted specifically in the work request. So the rest is just there for some reference on the project.
All right, thank you. I'll recognize the applicant.
Thank you, Chairman, and thank you so much to staff for such a wonderful presentation, as well as their help through this whole process. It's been a long night, so I'll try to keep the presentation very brief. I'll start with...
Please introduce yourself first.
I should do that, you're right. Keenan Condor from the City Attorney's Office, so office is in One Exchange Plaza, 10th floor. We have several of our experts here, which I'll let come up to the front and have them sworn in and introduce themselves first.
Good evening. I am Jennifer Heinz with Clark Nexon. I'm the architect for the project.
Hello, I'm Dale Tiska. I'm a City of Raleigh employee, and I work for Engineering Services, Construction Management Parks Division, and I'm project manager and engineering services supervisor.
Right. I'll go ahead and swear both of you in now. Please raise your right hands. You solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth. All right. Thank you.
So since no one wants to hear too much from attorneys, I'm going to hand the floor over to Jennifer in a moment to do the majority of the presentation. Before I do that, however, we do have several exhibits just for reference if it's required, but they're mainly for the record. We have 5 exhibits in binders, which I'll hand up to the chair if the chair will accept it. They are both of our expert witnesses' resumes, a portion of the application materials. We have photographs of the site, and lastly, some reference illustrative materials that we could look at if it becomes necessary. So if I can hand this to the chair to see if they'll accept it.
I accept the evidence.
Yes. And last exhibit for introduction, this will be Exhibit 6. We made some small changes to the plan in the last week or so that Jennifer will discuss. So this is just the updated application with that update. So while she's handing that out, the last housekeeping item for me is if we just have all these exhibits, the presentation, the staff report, and the application materials moved into the record for this proceeding.
Without objection, so ordered.
All right, now I'll just hand it over to Jennifer.
Hi, thank you. You have our full report, but what you're receiving right now is an addendum to that report. We received some information that we felt would impact the report last week, and that's with the respect of lightning protection system that we need to install for the splash pad as part of our safety measures for the park. And we just learned that the existing ones that the city has would not extend all the way to cover our new splash pad, so we needed to provide a new detection antenna. So what you're seeing there is how we have proposed to incorporate that antenna into the amenity buildings that are part of the new construction. We're recessing it into a well, if you will, right above the pump house, so that only about 4 to 6 inches of that antenna are visible from the ground, and the rest of the mounting is then recessed within that roof form. So happy to answer any questions about that or any of the other portions of our original application.
And before we turn over to the board for questions, we'd like to introduce Jennifer as an expert in architecture.
Without objection, so moved.
And lastly, Jennifer, is it your expert opinion that the proposal is congruent with the historic landmark or district?
Yes, it is.
Great, thank you very much. We're available to answer any questions that you have about the update or as well as some of the other features that have required this certificate.
Thank you. Are there any members of the public who wish to provide comment on the application? All right, seeing none, we'll proceed with committee questions. If there are any.
Yes, I do. Just a brief one. For these structures, for the siding material, you did mention in the application that the intent of that was to contrast with the historic structures on site. Are there any other structures around that have a similar material to that on them that can be referenced?
Not on the park site itself, but there are within the district and the larger district, there are the buildings along Barrel Drive there that are more light industrial, but were also very integral portions of the method community as it evolved.
Okay. And similarly for the inset wood siding, is that also mainly a contrasting reference to the other buildings?
Absolutely, and it's also a little reflective of the wood trim that you do find on the agricultural, also known as the Pioneers building. So that was something we were trying to tie those two buildings very delicately together. Also, one of those industrial buildings is Capital City Lumber, so also dealing with that and a modern interpretation of the use of wood on this project.
Gotcha. Thank you very much.
Question for staff. Just to clarify, this this is an historic property, not within a district.
Yes, that's correct. It's a landmark. It is not within one of our historic overlay districts.
And it's the one building you mentioned and just the property as a whole?
Yeah, the agricultural building was designated as a local landmark much earlier on. And there was a concerted effort in this area when it was determined it couldn't be listed as a full district, the method community, to prioritize landmarking individual properties instead. So there was a larger landmarking effort applied to the historic school campus. So there's 2 different designations, 2 different reports to reference, just different timing, but the same general historic significance.
Any other questions from the committee?
I have one. On the southeast elevation, page 9 of the packet that we all got,
Yes.
what is the material on the siding that connects sort of the 2 disparate pieces?
That is going to be an integrated louver.
Oh, it's a louver.
It's a louver.
Okay, so it's
It's air intake.
powder coated metal of some
It will be
kind?
to match the siding.
Okay, okay. Thank you.
And we did note in the staff report, additional details are made, and we're happy to provide those. At the point at which we submitted this, we were just coming out of design development. So we moved it further along and have that information ready for all.
Any other questions from the committee? All right, seeing none, we'll close the evidentiary hearing, move to committee discussion. Y'all can have a seat. Thank you.
Any thoughts other than?
This one is a little bit unusual for me. I do appreciate that they're modestly sized. They're within a context of another sort of modern splash pad area, and they are contemporary in design and not attempting to emulate their historic neighbors, which I think is a positive. I think it's the materiality of them that I'm a little bit struggling with. But I also am appreciative of the fact that they are contrasting. I don't know that I would love to hear discussion from the rest of the committee, because I feel like I'm a little torn on the congruity in my own mind.
I see them a little more like a collection of site features that are part of this project, which is like the in essence the park part of the project, and less of the building. And so I don't know. I feel like they did a good job of being like not hokey playful, but like playful and compatibility with like the splash pad and the park amenities that are being added in this part of the project. And being a landmark and not an HOD, there's like the context is limited. It's
Yeah, absolutely.
just a few existing buildings on site, and I feel like I see compatibility with the contrast that's there. Also, seems generally durable, which is good for a city building. And everything that's there has obviously been very durable and long-lasting too. So I don't know. I think there's some conceptual compatibility, but maybe that's not enough to sell you on the congruity.
And I would add, the compatibility that you mentioned, but also just deferential to, the main historic structures as well.
It's also, I've always thought this site had interesting roof lines, but they're not the same.
Mm-hmm.
And so I think, being differential, I think there's a case to be made for like a new series of roofs that are not the barrel of the gym or the church structure that's closer to the street along Method, and there's a flat roof structure. I feel like it's kind of all over the place, so that lends itself to something creative.
Mm-hmm. Yeah, no, the form I definitely appreciate as being something that it's a contemporary version of like a rudimentary maintenance hut, essentially, which I do appreciate. But that is helpful. Thank you, Rob.
Yeah, I think the thing that helped me, I think this like the site aerial that has that like very clearly lays out like what's contributing, and then when some of the like non-contributing pieces were added, and looking at like we've seen this type of picnic shelter that was added in 2003 all over the city. I don't know that I would take issue with more of those, but I like that this isn't that, that it's something, I don't know, just a little more contrasting. And it is a building this time and not a shelter. So, but it's still like, I think, again, to my first statement, it fits into the collection of pieces that are, making this like site amenity more of a place.
going back to your siding comment, I think one thing that's helpful, there's a predominance of brick on the main buildings. This proposed building, while obviously the siding is different, it's still a predominantly one material.
Yeah.
And then that way, I think it's definitely in keeping with
think
the
that's a
spirit
good
of the
point.
other buildings.
No, that is a good point, Melissa. I do think that's helpful.
Any further discussion from the committee? Jordan, any comments? All right. Based on the evidence presented by the applicant and the summary, staff summary, I move that the application be approved subject to the following conditions. One, that the following materials, let me make sure I'm on the right one. I am. Okay. One, that the following materials and specifications be submitted to and approved by staff prior to issuance of the blue placard. A, manufacturer's door specifications, including section details. B, manufacturer's skylight specifications, including section details. C, standing seam metal siding specifications, including pan width, rib height, and ridge cap profile, if applicable. D, south storefront assembly specifications, including section details. E, exterior lighting specifications, if any. So a motion's been made to approve the application subject to the stated conditions. Is there a second?
Second.
All those in favor say aye.
Aye.
Any opposed? Motion carries unanimously. Congratulations. The application will be final, or the approval will be final after the minutes are approved and signed at next month's meeting. Thank you. All right, the next on the agenda is COA 103-2025, 404 Kenzie Street. I ask the applicant to make their way forward and recognize staff for their presentation.
Mr. Chair, can we have a minute to switch out seats?
Yes. Thank you.
Bye, guys. Nice to see you.
Good to see you.
Catherine stood in for the city application we neglected to mention, but.
Where is Pat? Oh, yeah. There's Patrick. He's just outside. Yeah. Committee will be at ease for just a moment.
No, ironically, there, it was in a subdivision outside of, or no, it was within Southern Pines. And Southern Pines was like, Southern Pines was like, no. Not really, they didn't really have an issue with the buildings necessarily, but the way.
All right. Go ahead and proceed with your presentation.
Ready to go.
All right.
This is case 103-2025 for 404 Kenzie Street in the Boylan Heights Historic District. The request is to remove a rear enclosed porch, construct a rear two-story addition, construct the rear patio and site wall, remove rear concrete strips, remove a tree, and plant a replacement tree. This is a view from Kenzie Street of the subject property. And the front facade, there are largely no COA reviewed changes proposed to the structure. Here are the existing strips to be retained. The one change on the existing structure is this infill window proposed to be replaced with a new window. A view toward the rear and the strips to be removed. And the rear infill porch also proposed for removal. Existing rear facade, better look through the vegetation, and the south side of the property, moving back toward the front. Summary of staff concerns are contributing evidence to support the relationship of solids to voids for the proposed upper story screen porch were not provided. Evidence to support the proposed window muntin profile was not provided, and some additional construction details as well.
All right, thank you. Recognize the applicant to proceed. Please introduce yourself.
Yes. Good evening, Mr. Chair, members of the committee. Michael Birch, Longleaf Law Partners, here on behalf of the owner. Before I turn it over to Mr. Rusty Long, I will ask that you accept the application, staff report, and the staff presentation into the record.
Without objection, so moved.
Great. With that, I'll ask Rusty Long to come up.
All right, my name is Rusty Long. I'm an architect on this project.
All right, we go and swear you in, then you can proceed. Do you solemnly swear or affirm the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
I do.
You may proceed.
All right. Good evening. Thank you, Mr. Chairman and the Commission. I'm Rusty Long with Good Work Architects. I've been a registered architect in North Carolina for about 15 years. And in a past life, I served on a board similar to this one in Portsmouth, Virginia. So I appreciate your time and that you guys are here, and we will keep it short, hopefully. Our project proposes a rear two-story addition, patio, site wall behind this existing structure. The existing 1927 contributing house is intended to be fully retained with certain elements repaired. Those include restoration of that one existing window opening, as well as repairs to other windows, repairs to the porch, flooring, and masonry repairs to the chimney. The proposed addition was designed specifically with the RHDC guidelines in mind. It's located entirely at the rear of the property. It is not visible from the street. It's narrow and set back from the existing historic walls and roof line. The proposed materials are intended to be compatible but distinct from the existing structure. Those include a combination of fiber cement, brick foundation, and simplified window patterns that align with the existing in terms of pattern and height. As for the site itself, all the existing landscape features at the front will remain unchanged. We are proposing a removal of one pine tree at the rear that is currently leaning over the house with root structures impacting that rear porch. It's intended to be replaced with a hardwood tree of comparable canopy a little bit further back, but in the same general area of the yard. And a certified arborist has prepared a tree protection plan for all the other trees on the lot. We acknowledge staff's comments in regards to the porch and window details. We're open to conditions as needed to address those points. In particular, we have confirmed that the window manufacturer that we're proposing does provide a 5/8 putty-style profile to match the existing. And likewise, we're open to suggestions or modifications to the second floor porch if required, and are happy to provide all the additional details that staff has requested as part of our application. In short, our project seeks to preserve this historic house, differentiate the new addition from the old, and respect the district's massing and landscape patterns. And we believe that what we've designed here is consistent with those. But I'm happy to answer any questions that you guys may have. Thank you.
Thank you. Are there any members of the public who wish to provide comment on the application? All right, seeing none, we'll proceed with committee questions.
Hey, Rusty. Quick question about the upper screen porch. You saw the staff comments. I don't know if there was any additional evidence or anything you wanted to provide in response to that.
Sure, yeah. So we found a variety of structures in the neighborhood that have second floor porches. Some are over conditioned space, most are not. A lot of times they're actually on the first floor. We did find examples of second story porches over first story porches under a hipped roof in a similar configuration of this, but it was not the combination of all of those elements in one. We have modified in the updated version the porch detailing to be less open. It originally was more of a column with two voids, and we broke it down more to be on the scale with the windows.
Cool. Yeah, I mean, I can think of, I live nearby here, so I walk around a lot, and that condition is usually some form of like a sleeping porch, I think, would be the historical definition of it. But, I'm just pragmatically keeping water off of a screened space that's above conditioned space is always a challenge, but it's my only question. Otherwise, really good job like preserving the original house. It's a nice project.
Thank you.
Any other questions from the committee?
Yeah. Just a question about the windows. Obviously, you're retaining all of the existing windows.
Correct.
It seems like there's essentially two-ish types of new windows. There's sort of a double hung and then I guess a small picture frame window. There's four of them gang together on, I guess, the right elevation, and the the smaller picture frame ones appear to be like a
four light.
Like a four light. And the existing windows are, a 6/6. And the new, I guess, double hung windows are none of the above. I guess I'd like to hear some sort of rationale as to why you deviated from the 3 vertical separations and then went with no separations at all for some of them.
Yeah, I did want to point out that the ones on the side of that existing wall are actually a 4 instead of a 3 on that side porch. So we were going off of those as the precedent for them.
Sure.
And the other ones, I think we're open to either scenario if they needed to include muttons to be more consistent with the existing, or as a whole, we were specifically kind of riffing on that existing porch there. But I think that the applicant is open to going either direction if there's something that the committee has a strong preference on.
Okay.
Any other questions from the committee?
Yeah. Hey.
Hey.
You may have mentioned it and I might have missed it. The existing rear windows on the house, are those being removed and salvaged or for the addition?
Those are being removed and salvaged, but they're not intended to be reused in the
Okay.
building, in the new addition, yeah.
The only question I have is about your center second floor window on the rear elevation of the addition in similar through line. And you've got, your 1/1s and you've got your 4 lights. Can you give us some insight on your inspiration for your little guy there?
I wonder if I can get that. No, I can't pull that up. Can I? It's not in the staff, I can't throw that on the screen.
Oh, you've got some evidence for us.
We probably all have
It's probably
it here,
in there, yeah. Let me look, sorry, I probably missed it.
So in proportion, those are matching in size of the ones on the side. But because it's the rear of the structure and not facing anything else, we weren't trying to mimic that same 4 pattern over that particular space.
Cool. All right. Thank you. That was just me.
Any other questions?
Sorry, I have one more now that we're on windows, sorry. On the left side elevation, Rusty, the second story right next to the chimney, is that
That's an existing, yeah.
And it's an existing 1/1?
It's an existing weird 1/1 that's actually in a closet.
Okay. Got it. Thank you. No other questions.
All right. Any other questions from the committee? All right, hearing none, we'll close the evidentiary hearing and proceed with committee discussion.
Thank you.
Thank you.
Yeah, once you all pointed it out, I mean, just some cohesion to maybe some of the window patterning. Though there's clearly, that one window I just asked about is an oddball.
I just asked about it. I don't.
Yeah, I think we've got evidence in this application of oddball windows in this district.
Sure. Okay.
And I do appreciate that the majority of them are a nod to the original edition's windows. So I think for me, just at least knowing that we've got the background for that in evidence makes me feel a little bit more like this is Congress. And I do think the breaking down of that second story porch system makes it feel more like one of those sleeping porches without having to take it all the way to an enclosed, glazed situation or something.
Yeah, I think, the evidence they provided, it's like page 28 of the PDF, 1003 West South Street. It's not exactly the same relationship or configuration, but there is a full kind of screened porch and then a series of windows kind of to the side of it. So I think the applicant really summed it up well, where there isn't this exact configuration of elements kind of anywhere in the district, but I think they've done a good job of synthesizing them in a way that feels congruous or appears to be congruous, especially considering the evidence that they have presented. There's even some tripartite sort of window configurations in here. It looks good to me.
All right. Any other discussion? All right. Based on the evidence presented at today's hearing and the staff report, I move that the application be approved, subject to the following conditions. 1, that a tree protection plan be implemented and remain in place for the duration of construction. 2, that all new windows and doors have a smooth painted finish and 5/8 inches or 7/8 inches putty profile muntins if present. 3, that the following materials and specifications be submitted to and approved by staff prior to issuance of the blue placard. A, revised window muntin section details. B, manufacturer's door specifications, including section details. C, patio specifications and install pattern. D, physical paint samples. E, gutter/downspout locations. F, exterior lighting product data / specifications and locations, if any. G, HVAC unit dimensions / specifications, location, and screening details, if any. And H, a landscaping site plan and plant key with mature dimensions if altering from existing site conditions. Motion's been made to approve the application. Is there a second?
Second.
Any discussion or debate? Hearing none. Question for the committee's approval of the application. All those in favor say aye.
Aye.
Any opposed? Motion carries unanimously. Congratulations. The application's approval will be final after next month's meeting when the minutes are approved and signed. Thank you. All right. Last but not least, COA 104-2025, 520 Polk Street. I'll ask the applicant to come forward and recognize staff for their presentation.
All right, you're right. Last application. This is COA 104-2025 for 520 Polk Street. It is in the Oakwood Historic District. This is an after-the-fact construction of a 6-foot-tall rear fence and gate. It was a contractor error. So this is the view of the property from 520 Polk Street. And this is a view down the driveway looking towards the section of fence that was installed. Again, a closer view of that section as a view of the backside of the fence that was installed. And then again, just a detail. There are no staff concerns.
I recognize the applicant. You can please introduce yourself.
Good evening. My name is Eric Gable, and I'm happy to be here representing 520 Polk, which my wife and I just purchased and moved into in June. It's been our dream home for about 8 years. Thrilled to be in the neighborhood.
Let me go ahead and swear you in. Please raise your right hand. You solemnly swear or affirm the testimony you're about to provide is the truth, the whole truth, and nothing but the truth.
I do.
All right. You're recognized for your presentation. If you have anything else you'd like to add.
I don't have anything else to add. The pictures, I think, have spoken for themselves. We actually had planned to do a 42-inch fence after we learned of the COA differences, but the contractors neglected to change the work order and ended up putting in a 6-foot fence, which we were informed the best thing to do would then go be and get it after the fact. Same difference to us. We just wanted to be able to keep our dog in the yard.
All right. Seeing no members of the public here, there's no public comment on the application. Any questions from the committee? Nope. All right. I'll close the evidentiary hearing. Move to committee discussion, if any.
No.
All right. I move that the application be approved. Is there a second?
Seconded.
All those in favor say aye.
Aye.
Any opposed? Motion carries unanimously. Congratulations.
Thank you very much.
Thank you. Any other business to come before the committee?
I guess, good night. Just a question about, I guess, the quasi-judicial nature of this hearing in particular. It felt straight up judicial. I I have never been present for a cross-examination.
It was my first one as well.
Or, I mean, there are a number of things said that I've never personally witnessed here. So I guess I just want to take the temperature. And of course, like, you said it's okay, so I assume it's okay.
Yeah, part of the reason it's often not uncommon, I wouldn't say it's common, but occasionally a member of the public will, send an email to our Historic Preservation City account asking us to deliver these comments to the chair on a case. And we have to tell them that we can't provide those comments via an email statement. We hope they can make it to the meeting because through the quasi-judicial hearing, there has to be an opportunity for statements and facts inserted into the record for the person that makes those statements to have the ability to be cross-examined. That could be by you all with questions. That could be by the applicant trying to make their case. We don't have a lot of attorneys that come and represent cases here in other quasi-judicial, judicial boards in the city, like the Board of Adjustment. It's very common. It's very uncommon that there's not an attorney attached to those cases, so we're just sort of a different animal in the amount of times that we see. I agree, I've never seen it done straight up like that. Usually the comments are directed to the committee towards some other comment, but it's a part of the way the state has structured this process to work.
Yeah, I mean, the vast majority of public comment that comes from lay witness or lay testifiers, witnesses, I mean, it's not competent. I mean, it's like talking about, sometimes they'll talk about the whether it, meets the certain standards or not, but, a lot of what we heard today was, individuals talking about stormwater who have no basis of knowledge to be talking about that. So, yeah, I mean, and sometimes applications and folks that live in the neighborhood are passionate and, yeah. Sir, do you have any comment you wanted to add? Or
This was really well explained by Aaron, and I certainly share your observations. Yeah, a lot of the testimony tonight, not only not competent, but not material, was off the mark, had nothing to do with anything that was relevant to the findings. But, the committees of the city generally operate this way. There's some breadth given to folks that come in and testify, and it's harmless if the testimony's off the mark, so long as it's not relied upon.
Yeah, and I guess that's my last question. We can get out of here, but like, if she said, move to strike this stormwater or traffic testimony from the public, do we then just sort of pretend that we didn't hear that? Kind of like we were on a jury, we just can't.
Yeah, I mean, I was expecting Molly to actually make that motion specifically for Mr. Reese's testimony, but she didn't. But yeah, I mean, it's like you hear it, but it's, as Patrick said, it's not competent, it's not material, and it's not in our purview to even be reviewing. So it's just in one ear and out the other.
So it is true, the COA process does not review stormwater requirements or impacts. I'll say that case is still open, so we should probably not talk about it too much openly.
Yes.
Expert testimony is a thing, as you have seen. If all it takes to be an architect is have an attorney tender you as a witness, then maybe that's a tool open to others outside the applicant team. But it's things that are common sense for people having their lived experiences within these historic districts don't necessarily translate to the turn it on its head legal system that we have to work within. So I'll acknowledge everybody's feelings are somewhat true about what they are.
I will add that we may see more attorneys coming as people start putting their property in trusts and things like that, because anything that is not you owning it, if it's a trust, an LLC, or a church or anything like that, they're required to have an attorney. So it just is.
Anything else? All right. With that, meeting is adjourned.
And you can thank me for it ending when it did.